Okay. Good evening, everyone. Good evening. Yesterday, yesterday we had discussed education and reservation. Today we are going to discuss employment and reservation, combine all of it together and understand 15 and 16 from a comprehensive manner with certain Supreme Court judgments. Okay. So let us start. Now, Article 16 says equality of opportunity in matters of public employment. Now you would understand why yesterday when we discussed Article 15, which had two basic dimensions. One, that you should not discriminate against CRRSP, CRISP, caste, religion, race, sex and place of birth. That is why you will be able to correlate why that movie starring Ayushmann Khurrana was called Article 15 and not anything else. And the second part is of Article 15 was reservation in education. Now that reservation in education is applicable to what is called higher education and including private institutions as well. But we also understood yesterday that reservation is not applicable to minority institutions, which is why convents and madrasas do not have reservation policy. Now what we are going to discuss is education and public employment. Now, before I begin with this, I must also tell you very clearly and very categorically that I understand that as students preparing for a government exam, whichever category or caste or community you may belong to, you will end up having a certain view on this. Now, I cannot stop you from having your personal view, but I can definitely direct you from having the view which is required as far as the exam is concerned. Okay, and that is the view that matters. Your personal view, my personal view, what the news has to say, what everybody else has to say is irrelevant. What matters here is what we are talking about here is your exam oriented understanding of India's employment reservation policy. So Article 16 clause 1, which we are talking about, is your opening article. It is your umbrella article. It says there shall be equality of opportunity for all citizens, which means we are not talking about foreigners. This fundamental right is only and only available to citizens, which means reservation cannot be given to foreigners. What is very interesting to note is, while reservation can't be given to foreigners, but right to education, which is guaranteeing every 6 to 14-year-old free and compulsory education, that is the right which is available to both citizens and foreigners. So if there is a 10-year-old foreigner child in India, that child is also covered under Article 21A. Why is that the case? Because India has ratified an international document called the UN Convention on Rights of Child. And when you ratify an international document, which means that you voluntarily tell the world that you are going to implement the provisions of that document in domestic policy. And that is why India has done it. And when you ratify it, then the world rewards you with resources to implement it. This is why 75% of your Sarva Shiksha Abhiyan funds, which are now called Samagra Shiksha Abhiyan funds, are actually coming from the World Bank for the last 10 years. Anyways, let's focus on this. Article 16 clause 1 says, there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state, which means you cannot be discriminated against. Now comes the fun parts, the interesting parts. Article 16 clause 2. No citizen, only on the grounds of religion, race, caste, sex, descent and place of birth. Article 15 was CRRSP. Article 16 is Dr. Crisp, which is descent, residence, caste, religion, race, sex or place of birth. Only of or any of them, they are two very important words. Be ineligible for or discriminated against in respect of any employment or office under the state. Now let's understand some practical implications of Article 16 clause 2. Now let's quickly understand this as well as we can. Okay, so what we are basically saying is, under Article 16 clause 2, you cannot discriminate against any citizen and citizen only on the basis of Dr. CRRSP. What does this stand for? D for descent, R for residence, C for caste, R for religion, R for race, S for sex or gender, and P for place of birth. If you compare it to Article 15, again Article 15 is only available to a citizen, as we had discussed yesterday. And if you remember Article 15, I'll quickly show you Article 15 as well. If you remember Article 15, you will be able to see the grounds that were mentioned in Article 15. See, the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Right? Now understand this. So as far as Article 15 clause 1 is concerned, Article 15 clause 1 tells you only C, R, R, S and P. Again, caste, religion, caste, religion, race, sex or place of birth. I told you yesterday, the two most important words are only and any of them. This means you cannot discriminate against citizens on either C, R, R, S or P, or a combination of C, R, R, S and P. This is not allowed. But what if I want to discriminate on something else? That is perfectly allowed. Which is why when restaurants do not allow people to enter restaurants if they are wearing chappals or informal clothes, they have the absolute right to do so, because dress code is not mentioned. Not at all. If you notice, here residence is not mentioned. Here descent is not mentioned. So, when state universities give reservation to domiciles or to people from that state, then it is perfectly legal, because residence and domicile is X. This is why it is possible, because 15 is about education reservation and 16 is about employment reservation. So as long as that X is justified, is reasonable, the reason why you're doing X is to eliminate inequality, it is fine. So is it reasonable for a state university to reserve some seats for students who are domicile of that state? Yes. So that is why it is allowed. Do we understand this? Now see here. Here you have added descent and residence. Now understand, even if it is here descent and residence, it does not mention language, which means in your state civil services, your UPPCS, your Tamil Nadu PCS, your Karnataka State Civil Services exam, if you are compulsorily supposed to write a language paper, it is perfectly allowed because plus X is okay. So D or R or R or C or R or S or P, this is not allowed. A combination of D plus R plus C plus R plus S plus P is not allowed, but plus X is absolutely allowed. So if you, for example, you would remember in JNK, if you were not a domicile of JNK, you could previously not write Jammu and Kashmir State Public Service exam because they could easily do this. Now that you've taken 370 away, anybody can now write JNK. So if you're writing UP Civil Services, there is going to be a compulsory Hindi paper, whether you like it or not, because they can do so as language is not a problem. Similarly, physical capability. Now this is an outdated argument, and that is the government is planning to change. You cannot discriminate on gender, but what about the archaic orthodox notions of gender and physical ability? This is why women were not given full service combat roles in the armed forces, and it was perfectly legal, because the justification was, we are not just discriminating on gender, we are discriminating on gender and physical ability and the readiness of infrastructure. So today that is no longer reasonable enough. So that is why now women are given permanent commissions, women are going to be given combat roles. From this year onwards, the first ever batch of the National Defence Academy is going to have men and women cadets. Why is that the case? Because of this. So D plus R plus C plus R plus S plus P not allowed. DRR CRSP not allowed, but plus X absolutely allowed. And that plus X could mean anything as long as it's reasonable, it is just, and it is trying to solve a specific purpose. That is the beauty of Article 16 Clause 2. Understood this? So that is why it has been mentioned. That is why you understand domicile is never just about place of birth. Just because you are born in a state doesn't make you the domicile of that state. You should have lived in that state for X number of years, or finished some schooling or some college, or you should have demonstrated X number of years of living in that state. So, can you discriminate on domicile? Yes, absolutely. So this Maratha reservation issue is actually an outcome of 16 clause 2, and let me also tell you this in very clear places, this Maratha reservation issue, this EWS issue, none of this is relevant for the exam, right? Now Haryana government makes a law which says we are going to reserve seats in the private sector also, that private companies are going to have an X number of seats for people who are from Haryana. Now, that is a question mark, and we will discuss that in layer 2. Again, extremely irrelevant for this exam. I know it is very exciting for students because this is spoken about in the newspapers a lot, but this is absolutely not important as far as exam is concerned. And I'll discuss how the Haryana reservation issue has arguments both for and against. So we'll come to that later. Okay. So we've understood this so far. Now let's come back to Article 16, Clause 3. Right. Now 16 Clause 3 becomes an enabling article. Says nothing in this article shall prevent. Now understand this. Prevent the Parliament from making any law, which means if you're giving reservation, it has to always be through a law. It cannot be an executive order. It cannot be a scheme. It has to always be by a law passed by the Parliament. And the only people who have the powers to do so are the Parliament. Now, let's understand this. In regard to a class or classes of employment, which means Group A, Group B, Group C, Group D, or a combination of it, or an appointment to an office under the government or any local or authority within a state or union territory, any requirement as to residence within that state or union territory prior to such employment or appointment. Now, if you see, here it says nobody can be discriminated on the grounds of residence. But 16 Clause 3 says you can actually create a residential provision, but this can only be created by the Parliament. So 16 Clause 3 is nothing but an exception or a special case of 16 Clause 2. Please understand this. You cannot discriminate against anybody as far as government employment is concerned on the basis of residence, clearly mentioned in 16.2. But you can create a residence requirement, but that residence requirement must only and only be prescribed by the Parliament. It is the Parliament who will authorize that, okay, we are allowing for residence to be a requirement for a specific kind of appointment. This means that in India, the center is stronger than the states. This is also one of the arguments that are used in the Haryana reservation issue, which we will discuss much later towards the end of layer 2. Do we understand this? 16.2 says nobody can be discriminated on the grounds of residence. 16.3 says unless the Parliament makes a law making residence as a requirement. That's the basic difference. So if the Parliament makes a law that XYZ appointment to ABC office will require you to be a resident of that particular state, of that union territory, that is okay, no problem at all. That can be done, and this is in the original text of the Constitution. This has not been added later. Okay, this has not been added later. Okay, now how many times do I have to tell you to not interrupt me in the middle of the class by asking me questions? Vivek is asking, is ordinance available under 16 Clause 3? No, because you cannot make an ordinance for a constitutional amendment. Let me come to ordinances. So don't use your brains unless you've been asked to. Pay attention to what is being discussed. Okay? Now we come to the places where your policy has been given. Article 16 Clause 4 onwards. Your actual reservation starts from here. Nothing in this state, nothing in this article, which means nothing in Article 16, will prevent the state from making any provision for the reservation of appointments or posts in the favor of backward class of citizens, which in the opinion of the state is very important, not adequately represented in the services under the state. Please understand what this means. It means you are giving the second exception. First exception was Parliament can make a law authorizing residence. Now comes the major exception that if you want, then, now please understand, here it is prevent the state. State here means both center and the states. So both the center and the states can make a law. Both the center and the states can make a law, can make a provision for reservation on the basis of backward classes for those people who have not been adequately represented under the services of the state. Now you see in Article 15, it was clearly mentioned SC, ST and backward classes. Here it is only mentioned backward classes. So you will have to create some further explanations of this. And that is why later in the constitution, Article 16(4)(a) was added to explain exactly what we are talking about, and we will get this part right. Okay, understood this? All right. So, Article 16(4)(a) now was added through the 77th Constitutional Amendment. This was added through the 77th Constitutional Amendment and the year is 1995. Now, nothing in this article shall prevent the state from making any provision for reservation. Then this was added later in matters of promotion with consequential seniority to any class or classes if of posts in the services of the state under the state in favor of scheduled castes and scheduled tribes, which in the opinion of the state are not adequately represented. So they've given very specific explanation that backward classes were covered here, but now this also means scheduled castes and scheduled tribes, and they mentioned two very important words. There is going to be reservation not only at the recruitment stage but also at the promotion stage. And I must also tell you, this promotion part has not been implemented yet. It is legal now, but it has not been implemented yet, and with consequential seniority. Now, I will explain all of this together, don't worry about it. Now, next part. Now, this part which we are talking about as far as promotions is concerned, this promotions part was added through the 85th Constitutional Amendment of 2001. Through the 85th Constitutional Amendment of 2001. I will show you how Supreme Court judgments were parallelly getting here or there. But इतना समझ में आया कि अभी सरकारी नौकरी में रिक्रूटमेंट में भी रिजर्वेशन है, प्रमोशन में भी रिजर्वेशन है, बस इतना समझ में आया. SC, ST, OBC तीनों के लिए रिजर्वेशन. अभी तक इतना ही है. That in government jobs there is reservation for SC, ST and OBC for recruitment. Now, let me be very clear on this. But for promotion, it is only and only for SC and ST. Backward classes do not get reservation in promotion. Okay? Now, 16(4)(b). This was added by the 81st Amendment of 2000. 81st Amendment of 2000. यहाँ क्या लिखा है बहुत ध्यान से देख लेना, very important. Some very important policies. Nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are being reserved for being filled up in that year in accordance with the provisions for reservation made under 4 and 4A clauses as a separate class of vacancies to be filled up in any succeeding years, and such class will not be considered together with the vacancies of the year in which they were being filled up for determining the ceiling of 50%. This 50% was given by a Supreme Court judgment called Indra Sawhney case on the total number of vacancies. ये इतने लंबे चौड़े आर्टिकल का सिंपल मतलब है द कैरी फॉरवर्ड रूल ऑफ रिजर्वेशन. The carry forward rule of reservation, which is going to be applicable to SC, ST and other backward classes. To SC, ST and other backward classes. What is this carry forward rule? You will have to give me 5 minutes. I will explain this to you after 5 minutes. Once I am done with all the provisions ऑफ आर्टिकल 16. तो अभी तक हमको 2-3 बड़े हैवी वर्ड्स मिले हैं. कॉन्सिक्वेंशियल सीनियरिटी, देन कैरी फॉरवर्ड रूल. ये मैं बताऊंगा अभी आपको, डोंट वरी अबाउट दिस. ओके, चलिए आगे बढ़ते हैं. देन कम्स 16.5 एंड 16.6. 16.5 अगेन लेट्स अंडरस्टैंड. यहाँ पे भी एक पॉलिसी दी है. Nothing in this article shall affect the operation of any law that provides that the incumbent of an office in connection with the affairs of religious or dominational institutions or any member of a governing body shall be a person professing a particular religion or belonging to a particular domination. Basically इसके दो मतलब हैं, ध्यान से देखना. Nothing in this article shall affect the operation of any law which provides incumbent of the office मतलब holder of an office in connection with the affairs of religious or dominational institutions मतलब denominational मतलब any religious संस्था, कोई ट्रस्ट, कोई मंदिर की ऑर्गेनाइजेशन, कोई मस्जिद की ऑर्गेनाइजेशन, उनकी बात कर रहे हैं. और any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular domination. Okay, so दो बातें हैं इसमें. पहला तो religious institutions में reservation नहीं लगेगा, which we were discussing in 15 also. And second, you cannot make a law saying that a member of the religious institution must be of a specific you cannot stop this that a member of a religious institution has to that can be from any religion. ऐसा कुछ नहीं है. अगर शिरडी ट्रस्ट है और जैसे वो कोई टेम्पल का ट्रस्ट है, उसका हिंदू होगा तो हिंदू होगा, ये कानून में है. And this cannot be stopped. Nothing in this article shall affect the operation of any law which provides this. मतलब अगर कोई ऐसा कानून है जो कहता है कि भाई हमारे धार्मिक संस्था के या गवर्निंग बॉडी में ऐसे ऐसे लोग होंगे, उस पर रिजर्वेशन नहीं लगेगा. एंड सेकेंड, इफ देर इज अ बॉडी और ए पर्सन ऑफ ए स्पेसिफिक रिलीजन कंटिन्यू टू बी सो. आप ये नहीं कह सकते कि यू कैन नॉट कि जो होता है ना विश्व हिंदू परिषद, कि विश्व हिंदू परिषद का जो हेड है वो हिंदू ही होना चाहिए. वो होगा, वो कानून कहता है कि वो होगा. आप वहां यू कैन नॉट चैलेंज दिस इन द कोर्ट सेइंग व्हाई इज द विश्व हिंदू परिषद हेड ओनली अ हिंदू. because by law you can do that. This does not apply to that. समझ में आया? So if you're a religious institution, reservation policies do not apply to you. Extremely irrelevant as far as the exam is concerned. This is too controversial to be gotten into, so don't worry about it. Okay? Yes, yes, Abhishek, it is. Now we look at 16 clause 6. 16 clause 6. Alright, now 16 clause 6 is India's latest amendment. ये EWS वाला है. 103rd constitutional amendment which was passed in 2019. ठीक है. Remember in article 15 also this was a part. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of EWS, economically weaker sections, other than the classes mentioned in clause 4 in addition to existing reservation, subject to a maximum of 10%. अब इतनी कॉम्प्लिकेटेड चीज़ों को एक टेबल में क्लियरली समझते हैं कि ये होता क्या है. ठीक है, कॉम्प्लिकेटेड है नहीं एक्चुअली. सो वी आर नाउ गोइंग टू डिस्कस, एंड प्लीज अंडरस्टैंड दिस, इंडियाज reservation policy. Now, India's reservation policy has firstly two dimensions, and this is what is called horizontal and vertical. इसका क्या मतलब हुआ कि दो जगह पे लग सकती है. ठीक है, I'll come to this, don't worry. Horizontal and vertical. Firstly, India की reservation policy works on what? You have layer 1 SC, ST, OBC and EWS. This is your reservation. This is layer 1. Layer 2 can be women, children, disabled persons with disability and so on and so forth. ये दो layers हैं and both of these layers have to be merged. That is why it is called horizontal plus vertical. क्या मतलब हुआ इसका? This means, please understand this. This means, suppose there are 100 seats. Okay, out of which 50 are reserved and 50 are not reserved, and let us assume all of these 50 seats for simple purposes. Say there is SC, ST, OBC. Now OBC has 27 seats. It is not 27 seats. This is 20. Out of this, it is out. There will be PWD OBC and non-PWD OBC. That means people who are persons with disability and belong to OBC, and people who are not people with disability and belong to OBC. It gets integrated. This is what is called horizontal and vertical reservation. Okay, so this is the basic policy. Now let us understand where all in India reservation is applicable. In three basic places. First, in representation. Second, in education. And third, in employment. Now, as far as representation is concerned, this is done through the constitution. You have reservation for SCs and STs for Lok Sabha and state legislative assembly seats. A few constituencies for the Lok Sabha and a few constituencies within a state for MLAs are reserved for SC and ST candidates. This means the only people who are going to contest an election are going to be from this specific category. Only SCs can contest an SC constituency. Only STs can contest an ST constituency. Okay, so for Lok Sabha and state legislative assemblies, this is your reservation. Okay, then this is very interesting. In local self government, your sarpanches, heads of blocks, heads of zilla parishads, you have two layers of reservation, horizontal and vertical. First, you have SCs and STs. So some villages are declared SC villages. So the sarpanch from that village must necessarily be an SC community person. Or some villages have an ST community, have been declared an ST village. So the sarpanch from that village has to necessarily be an ST person. This is compulsory. Okay, this is compulsory. Then if the state wants, they can give for other backward classes also. This is the first layer. Now comes the most amazing second layer. 1/3 reservation for women. In every state in India, 33% of the sarpanches have to be women. You have to be a woman, otherwise you cannot contest. The state will decide which village are we going to declare, and this is done on a rotational basis. So if this is a village that we are talking about, which has been declared an SC village, and the government has decided for this tenure, this village will also have a woman candidate, then only a woman SC person can become a sarpanch. Only a woman SC person can become a sarpanch. So this is the interesting discussion for politics. Today you are saying that we should give reservation for women in the parliament as well as state legislatures. आज इसकी बात हो रही है. Because half the country's population are women. And not even 20% of our MPs are women. If women have to be given representation here, they should be given representation here. This year in the mains question also they had asked you, and I have already given this in your notes before the mains exam, that should there be some representation of women in the judiciary as well. Because unless you have a lady Supreme Court judge, you will not be able to give a gender sensitive judgment. So should you have a minimum number of women Supreme Court judges? 2021 has been a glorious year for Indian Supreme Court. In the history of this country, we have the maximum number of female Supreme Court judges. The maximum number in 2021, 9. That's a very important number. Okay, we're looking at a 9 number. We're still not there yet, but maximum in the history of this country. Not even a single Chief Justice of any High Court of India is a woman. There has never been a woman Chief Justice of India. So there are some very important, reforms that we have to do. So this is the representation part. We will cover this, in detail later. But Articles 15 and Article 16, they refer to education and employment. This is mentioned elsewhere in the Constitution. This is not in Part 3. Part 3 is not about this. But when you are giving special provisions for women, this is under the 73rd and the 74th Amendment, the philosophical basis is your Article 15. Okay, Article 15. Anyways, but if you notice, The Article 16 does not mention that you should have special provisions for women and children. So Article 16 nowhere mentions reservation can be given only on the basis of women. Okay? Anyways, so we'll now spend some time on education and employment. We had discussed this. So when we're looking at general reservation policy, now let's understand this as clearly as possible. We have broadly reservation in education, and we have a reservation in what is called employment. Now, as far as reservation in education is concerned, the important part, two kinds of education. First, school education, and second is college education. Education in school is governed by the 86th Constitutional Amendment of 2002, which inserted Article 21A, which is called Right to Education. And this is why the Parliament was able to make, remember, the Parliament by law can only make a reservation policy. So the Parliament made the Right to Education Act. Your reservation in schools is given here, not here. It's not in the Constitution, it is in an ordinary law called Right to Education Act. And the Right to Education Act, right, in the Right to Education Act, you have, please understand this, and this reservation is applicable to private schools. This reservation is applicable to private schools, where 25% of the children must be from EWS category. And this EWS category will be defined by the government. This EWS is completely different from there. This is EWS for the purposes of school education. This is not EWS for the purposes of college or employment. Understood this? So this means there is no SC, no ST, no OBC reservation per se in schools. And in government schools, because you have right to education, everybody should be admitted as much as possible. Now comes college. College education is of course under Article 15, right? College education is of course under Article 15. Here, both government colleges and private colleges, where it cannot apply to, are minority educational institutions. And here you have reservations which are horizontal and vertical. So layer 1 of reservation, SC, ST, OBC and EWS. Layer 2, some colleges can have reservation for women, persons with disability. Some colleges give reservation for children of martyrs, ex-servicemen. So you have, that kind of a war kind of a quota, so on. And let's say some of them have domicile quota or things like that. This gets merged here. This gets merged here. Understood this? So this is what is called your education reservation. Now is the difficult part, the employment part. Pay absolute attention to this. SC, ST, OBC plus EWS plus general. SC, ST and OBC, this cannot be more than 50%. EWS is 10% and general is now 40%. So 40% of the seats are actually available now for general category, and this is what is called layer 1. On top of this, you can add persons with disability. So SC disability, SC non-disability, ST disability, ST non-disability, OBC disability, OBC non-disability. Now they have included non-creamy layer, which means there is going to be a social and educational backwardness criteria and an economic criteria. SC and ST is purely based on social and educational backwardness, and EWS is purely based on economic backwardness, which is why there is a very pressing need for India to now have a socio-economic caste census, so that we know exactly the percentage of people who are economically backward as well, because otherwise it is a proximate number. Okay, so this is your first and basic layer. Okay, SC, ST, OBC not more than 50%, and then EWS 10%, general category 40%. This is the first part. Okay, now comes the second part. See, none of this was a part of the original text of the constitution. Remember, SC, ST was added later. We discussed the constitutional amendments right now, the 77th amendment and so on and so forth. Then OBC was added. This is very popularly known on the recommendations of the Mandal Commission, right? So they recognized that there were so many castes who were not traditionally under SC and ST, but they were also socially and educationally backward, so they must be given reservation. The government accepted this, and 27% reservation is for OBCs. This 27% is within your 50%. So 27% of the total thing. The 27% goes to OBC, 23% goes to SCs and STs, right? So this is your basic understanding of the distribution of vacancies, right? Now there is a debate that SC and STs should also have a non-creamy layer, because if your parents are IS officers and you're in the SC community, then your children may not need that reservation. And what is interesting to notice, the people who are demanding non-creamy layer are from the SC ST community, because this is not affecting general category, because this is a classification within a classification, because the Dalit organizations are saying that the people who really need it are not able to get it. So that is why have an economic layer, a creamy layer. How you have in OBC, that if the parents have been in a government job with certain specific conditions, then the child cannot get OBC reservation. Anyways, this is that. Now, SC and ST reservations, there are two things you must understand. SC and ST reservations, the list, who is an SC community, who is an ST community, what caste comes under SC and what caste comes under ST. Now you must understand, in India, you cannot give reservation on the basis of religion, and you cannot give reservation on the basis of caste, because caste is socially and educationally backward. That is how you have caste-based reservation. The fundamental idea is social and educational backwardness, and lower castes are socially and educationally backward, so they have been given SC and ST reservation. And SC and ST reservation is a uniform nationally integrated list. There is one list which is maintained by the central government. And if you are an SC in one state, you are an SC all around the country. An SC in Maharashtra will also be an SC in UP, will also be an SC in Rajasthan, will also be an SC in West Bengal. These are uniform lists, SC and ST. But OBC lists, they are state specific. Every state has its own list of other backward classes. So, for central government jobs, the central government has its own list that says we recognize the following castes from the following states as OBC in that state. So if you are applying, and this is very important, your UPSC forms are going to come out. For those of you who will be availing this reservation, your OBC certificate must clearly say that you are an OBC under, okay, you are an OBC under what is called the central list. You are an OBC as far as UPSC recruitment is concerned. Because a lot of times students have OBC certificate, but only for their state government jobs, not for central government. So you can be OBC in state 1, but not OBC in state 2, and not OBC as per the center. And the state should have the power to determine who can identify, which is what your latest constitutional amendment has been, where you have said, the Supreme Court basically said the states don't have the power. But then the constitution, the parliament overruled the Supreme Court by making an amendment saying, no, the states have the power to identify who is a backward list and we'll take it from there. So that is the case. That's the first element. Don't worry about it. In the exam, very honestly, none of this is going to be asked, because reservation as an analytical issue is not asked in the exam. That's the first, and there's a reason why. The UPSC will never ask you your opinion on reservation, because if they ask you your opinion on reservation, that means there is a discrimination on your opinion. Because if you're somebody who's a general category student, you may not understand the nuances of it and you may disagree with it. The examiner may also have a bias on it. And you remember, you cannot discriminate on the basis of caste, which means if there's a question on caste and somebody is writing an answer on caste, based on that answer, somebody may get less or more marks. Which is why in the history of this exam, they can never ask you, what is your opinion on reservation? It would be a violation of a fundamental right of the student appearing for the exam. That is why they never ask you. Similarly, they will never ask you a specific religious question. Do you think women should have been allowed Sabrimala? Do you think Santhar should be legal? Because your opinion will depend on the religion that you come from. And you cannot be discriminated against in a government exam on the basis of your religion or your opinion. Okay? Now, let's understand this. Let's get this right. And let's move forward. SC and ST are also Indic reservations, which means SC, STs are not religions of Christianity and Islam. They do not get SC, ST reservation. They only get OBC, because caste in India has primarily been originated from the Hindu mythology, right? So SC, ST reservation is Indic religious, which means religions which have said to be originated in India. So Hinduism, Buddhism, Jainism and Sikhism. All of these 4 religions were introduced in India. They originated in India. So SC, ST is a reservation only available for those. In fact, it is also considered a criticism of the policy, because you still have castes in Muslims, you still have castes in Christianity, if not castes, but at least sects and subsects, right? So that is the case. So this is something that we understand. What do we understand? We understand that this is social and educational, this is social, educational and economic, and this is economic, and this is general category. Okay? Now, we also understand that SC, ST is nationally uniform, OBC can be center as well as state. What do we understand? Mandal Commission 27%, 23% SC/ST, so 23 plus 27, 50, and remainder 50 is EWS and general. So EWS has actually been carved out of general category. Okay, and this is layer 1, and their layer 2 could be PWD, for example. Now let's come to the policies that had to be discussed. The first is what is called carry forward policy. What is first called carry forward policy? Now, carry forward policy is available only for employment, not for education. It does not mention education, it only mentions employment. Now see how this works. Let us say there are 100 seats, SC, ST, OBC, EWS, and let us say general. General 40, EWS 10, OBC 27, SC, ST 23. I'll give you the exact numbers later, not important right now. Let us say out of the 100 seats, there were 10 seats that were left vacant. There were 10 SC job seats that did not get filled. Okay, very possible. Okay. Now there is a Supreme Court judgment called Indira Sohni, which says reservation cannot exceed more than 50%. This is why it was here till 50%. Now when EWS gives you additional 10%, that technically makes reservation 60%. This is why EWS is currently challenged in the Supreme Court. But the idea is, this reservation is on economic grounds. This reservation is primarily on social and educational backwardness. So there are arguments on both sides. Now, anyways, so let us say in 2021, there were 10 seats that belonged to the SC community that did not get filled. These 10 seats are not going to be given to anybody. These 10 seats will be left as it is. In 2022, you will have 100 plus 10 seats, and these additional 10 seats will be added here. So here you will have 33 SC/ST seats, and if this violates the 50% rule, that is perfectly okay, no problem at all. This is called the carry forward policy. This is what is called carry forward policy. Okay, carry forward policy. You're carrying forward the reserved seats from the last year, if they are not filled, to the next year. In reality, this never happens, because there will always be at least 10 people from a community applying for a specific job. So, but in case there is a vacancy, that is completely okay. That is perfectly allowed. Okay. So this is the carry forward rule. Now comes the next part, promotion and consequential seniority. Promotion and consequential seniority. Promotion and consequential seniority. Promotion means beyond recruitment, there is going to be reservation in promotion as well. Okay? This has not been implemented yet. This has not been implemented yet, but it can be implemented. The basic idea here is, this promotion in employment is perfectly legal as far as the constitution is concerned. So, how will this work? Suppose, let's take your case. You guys are all going to become IS sooner or later. So, how is this going to work? After 10 years, you will be eligible to become joint secretaries, right? Now let us say at the central government, there are vacancies of 100 joint secretaries. You will have reservation here also, because there are severe underrepresentations of people from lower castes in higher offices, in fact negligible. How many SC/ST cabinet secretaries do you know? Zero. How many SC/ST defense, foreign, finance, home secretaries do you know? Absolutely zero. So this is why there is reservation in promotion. Okay. Now there are Supreme Court judgments. Jarnail Singh and so the Jarnail Singh judgment, which basically gives you certain technical guidelines to this, that there must be representation, there must be underrepresentation, and should not hamper the workflow of the government, and so on and so forth. Okay. Only in SC, Devendra, it's only in SC. I was giving you a total number. Now we'll come to the Supreme Court judgments. That's later. Consequential seniority means, suppose you are all of the 2022 batch. Okay. Let us say in 2032, some of you become joint secretaries on the basis of reservation. That means you will become seniors in your batch. You will continue to remain seniors for the rest of your careers. This is basically what is meant by consequential seniority. This is what is meant by consequential seniority. That if you have been given promotion on the basis of reservation, and that promotion has given you a seniority, then you will continue to have that seniority for the rest of your careers. Okay. So this is basically what your broad reservation policy is. Right? This is what your broad reservation policy is. Okay. In your employment. Alright. Okay. Alright. Understood this? Yes. ये समझ में आया. Now there are two judgments here, the Nagaraj case of 2008 and the Jarnail Singh case of 2018, wherein there are Supreme Court guidelines on the matter, right, which basically tell you that you have to make sure that there is underrepresentation of SC/ST community in the higher ranks, and you have to make sure that by recruiting SC/ST officers, it's not going to cause any inefficiency in administration. Later on in the Jarnail Singh case, the Supreme Court has said there is no need to give any data for it. We understand that there is a genuine lack of representation, and the fact that everybody is cleared such competitive exams, they will have some basic ability to begin. Right? None of these have ever been asked in the exam. None of these will ever be asked in the exam. Okay. By the way, when we were discussing representation based reservation, you would remember that this SC/ST reservation is always valid for a 10-year period, and we have to keep extending it. Very recently, we've extended it for another 10 years. So because of course today reservation is, is a very important policy issue for the country. ठीक है, तो इतना आसान है और कोई कॉम्प्लिकेशन नहीं है, बस इतना ही आसान है. ऑल राइट, बस सिंपल एज दैट. ठीक है, क्लियर. दिस इज आर्टिकल 15 एंड दिस इज आर्टिकल 16. ओके, अंडरस्टूड. बस there are important judgments, Indra Sahni, Jarnail Singh and Lakshmi Narayan, which we will cover when we do the analysis of reservation policy, and I will teach you how this has to be done. Rudra Pratap Singh could not get consequential seniority. But a consequential seniority in one line basically means if somebody has been given promotion on the basis of reservation and that makes the person a senior to the rest of the batch, the person will continue to be a senior. Just that doesn't matter if that was because of reservation and promotion. Okay, if the person becomes a senior officer. Dipanshu Sharma. No, you don't have to mention it. Nobody is going to ask you this in the exam. Ravi Pratap, can you explain carry forward? Carry forward is the seats that don't get filled as far as government employment is concerned from a specific category. They are added next year even if it violates the 50% rule. Right? Carry forward rule applies. Yes, Adarsh. Okay. So are we done? Are we clear with this? There are now technical guidelines which says that it can be applied. Okay. All right. You can take a 5-minute break now. Then we'll start with Article 17 and 18, Untouchability and Abolition of Titles. They are very simple articles. But this is what reservation is. और मैं reservation का आपको technical analysis दूंगा कि ये सही है या गलत है. एक तो anybody who says reservation is anti-merit, it's actually a very flawed argument. We'll understand why it is a flawed argument. I'll also explain to you why there is something called a caste privilege. कहा जाता है अगर आपको आपकी जाति नहीं पता है तो आप ऊपरी जाति के. ये बहुत इंपॉर्टेंट बात है. अगर आपको आपकी जाति नहीं पता है तो आप ऊपरी जाति के. ठीक है. So we'll understand this later. We'll understand the consequences of it. Okay, right? Okay. Raksham, yesterday we discussed Article 15 says you can make special provisions for women and children. Article 16 doesn't mention that in any article. Yes, you can take a 5-minute break. You can write it in your own words, Sindhu. You don't need to write it verbatim. Nobody has to ever make you write it verbatim. Five minutes break. Yes, government can make laws on OBC. Yes, Riya, it is irrelevant for the exam. No, Shivam, that's because Gujars were able to prove that they were socially and economically backward. No, you cannot change your caste in India. You cannot. You can change your religion, but you can't change your caste. Yes, Govind. Yes, Abhay Kumar Gond. If the government wants it to, Shashi. Uh, okay. If you're in Shivendra, read the EWS notification. I will not get into this. In Devendra, Nagaraj and Jarnail Singh, basically Nagaraj said you have to give data to prove that there is not going to be a lack of efficiency if you promote on the basis of reservation. Okay, so yeah. Vivek, I will discuss OBC issue for local bodies in Maharashtra and local bodies, not relevant. Okay, yes, Yukta, I'll have a look. Should SC and ST? I explained that we should not. Bhivsen, just please mail me about this. If an SC woman marries a general man, then the child does not get reservation. But if an SC man marries a general woman, then the child gets reservation. Okay. Act of defense is an exception into the murder charges. The states have a different criteria. No, they don't. Okay. No, changing in surname does not mean change in caste. Okay. In my 10 years of teaching, I have always seen the most amount of doubts that children have are always with the reservation. The least important topic as far as the exam is concerned. Right? Okay. Now, don't worry, we'll do a full analysis of reservation later in terms of whether it's right or wrong and what is the opinion that you should have. We'll discuss that later. It's not needed at the moment. Chaliye. Abolition of untouchability, an extension of articles. So, abolition of untouchability is Article 17. Untouchability is abolished and its practice in any form is forbidden. This any form means that even if it is by the state or by a private organization, institution or a person, it's not allowed, right? The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with the law. Now, this means that the Constitution declares that untouchability should be a criminal offence, but because the Constitution is not a criminal law, it says that you should make a law very specifically criminalizing untouchability. So, of course, you have laws such as the Prevention of Atrocities Against SC/ST Act and so on and so forth, right? This should be covered in your vulnerable sections portion in governance and also in social issues, but the general law is very simple. The law says that the Article 17 says that it is available for both, it is available for against state and private both. It can also be applicable for citizens as well as foreigners because it does not specify citizens only, and it is a non-self-executory right, which means that in this case the parliament will have to make additional laws to ensure that untouchability is a criminal offence. Okay, untouchability is a criminal offence. Right? Vishwajit has asked a question I don't understand, but I'll read the question. Very interesting question. If reservation in local self government is for SC general, and then SC women can elect, but vice versa is not allowed. Frame your question properly. Okay. Anyways, so this is Article 70. Very simple, and this also tells you untouchability is an outcome of equality. It does not necessarily lead to exploitation, which means just because you're practicing untouchability against a person, that does not necessarily mean that you are exploiting the person. In the prelims, there have been previous year questions on this regard. So I thought I'll bring this to your notice. Otherwise, this has no mains relevance. Barely questions come from here in the pre. But of course, you can quote this as a provision when you're talking about caste violence or the ill issues which are faced by people, because of the communities and the castes that they come from. Okay, right? Sort of mail me that question separately. Okay, now let's look at Article 80. Not a very important article anymore because it's outdated in its essence. There was a question this year in the prelims on Article 80, but a very, very basic question. Here also I see students asking a lot of questions. While your questions are valid, but this is not, very relevant as far as the exam is concerned. So Article 18 says, Clause 1, no title not being military or academic distinction shall be conferred by the state, which basically means a military title and an academic title is perfectly allowed. A military title and an academic title is perfectly allowed. And this means this military title or an academic title has been given to you by the state. So military titles could also mean, say for example, the ranks that are often given to people, not just ranks, but any sort of say field marshal was a title. Manik Shaw, there's a movie coming on him very recently. That's allowed. Writing a PhD after your name, that is allowed. Writing LLB after your name, that is allowed. The degree has been conferred to you by the state, by a state-owned university. That's allowed. So apart from that, no other title can be conferred. By the way, IAS, IPS, these are not titles, these are professions. So while people write IAS or IPS after their names, this is not in the concept of a title. I mean, it's not, you can't formally use it, that's okay, right? Now, the other most important part here is, this is referring to titles and this is not referring to awards, which basically means that Bharat Ratna, Padma Bhushan, Padma Vibhushan, all of those things is okay. That is perfectly fine. That is no problem at all. You can continue giving as many awards as you want. Military awards, civilian awards, sports awards, cultural awards. These are awards. Awards are not titles. Okay. Now, 18 clause 2. No citizen of India shall accept any title from any foreign state. Now, title from any foreign state means very important. Like for example, Amitabh Bachchan had recently gotten, not recently, a while ago had gotten something called Legion of France, which is actually not a title but an award which was given by France. The terms and conditions here is that if there is a title being given to you, you need to seek permission from the government of India on whether you can accept the title or not. That is an interpretation given through various Supreme Court judgments. None of this is relevant as far as your exam is concerned. These are two minuscule issues. Then you have 18 clause 3. No person who is not a citizen of India, which means no foreigner, while you are holding an office of profit or trust under the state. People often attach the word, a sense of negativity to office of profit. No. Office of profit means any office through which you're deriving some kind of gain. This is basically a salary. So all of you are going to be holding offices of profit. You're going to be working for the state, right? Okay. You're going to be holding offices under the state. You're going to be paid by the state. So that is perfectly fine. The problem is there are certain exceptions to office of profit. There are certain things that are not allowed in office of profit. Like for example, you can't have two parallel offices of profit in the government. So you can't be, heading a PSU and also be an MP or an MLA at the same time. That's an office of profit. And sometimes there are exceptions also. Like how the Vice President of India is the Vice President also and the chairperson of the Rajya Sabha also. That is an exemption under office of profit. We'll cover this in parliament later. But the idea here is anybody, if there's a foreigner who's working for India, simple explanation. If there is a foreigner who is working for India, you cannot accept anything from any foreign state without the consent of the president, which is basically the Council of Ministers or the Government of India. Fair enough. Now, 18 clause 4, no person holding any office of profit or trust under the state shall, without the consent of the president, accept any present emolument or office or any kind from any other foreign state. This basically means that, for example, if you are if you're a citizen or if you're not a citizen, but if you are working for India, then without the consent, without the approval of the government, you cannot work for another country, you cannot accept any advances or gifts from another country. Like, for example, when some of you guys as civil servants go on UN deputations, right? Now, technically the UN is not a foreign state, but even when you have to go to the UN, your UN deputation has to be approved by the government of India. Otherwise, you can't go to the UN, right? So that is that. Okay. Now, this is exactly how this works. This is exactly how this entire ecosystem is. इसके beyond, honestly, प्री में कुछ नहीं आता है, कुछ भी नहीं आता है, कोई point नहीं है. Okay. Vishwajit, in Lok Sabha election, in LSG election, if seat is reserved for OBC, if SC, then more and male and female can apply, but it's only reserved for women, then men are not allowed. Yes, absolutely, because this is not on employment or education. This is on representation. Representation is not covered under 15 and 16. Okay, that is why. Okay, is article 14 to 18 clear? समझ में आ रहा है? सिंपल है, इसमें ज़्यादा दिमाग लगाना ही नहीं है, टेंशन ही नहीं लेना है. आर वी ओके विद दिस? बस इतना ज्ञान मिल गया. आर्टिकल 14, 15, 16, 17, 18, इसके ऊपर एग्जाम में कुछ नहीं आता है. ठीक है. Of course, there are extensions to this. We will do them. We'll do the reservation debate towards the end of our rights issues. But is this enough at the moment? Do we understand this? Yes. No, Riyajit, all India quota is not important. I will discuss these current issues. What I'm going to do is, I'm going to start making these current affairs polity videos on my YouTube channel from next week onwards. So all of these current issues that keep coming up, I will cover them under a current affairs series called Water Week. So you can have a look at that. I have a Telegram channel called Atish Mathur Official, and of course a YouTube. I'll cover those issues. Thank you, Pankaj. अनुज के सवाल देखो भाई साहब. If an SC person of Hindu religion gets converted to Islam, which does not have SC caste, but in India caste does not change, so can he avail? Yes. Haryana ka reservation we'll discuss in the analysis later. Not needed at the moment. इतना हमको एग्जाम के लिए रेलेवेंट है. हरियाणा इशू, ऑल इंडिया कोटा, मराठा रिजर्वेशन, we'll cover them in the larger reservation analysis. अभी नहीं. अभी इतना हमको बस इतना पता होना चाहिए कानून क्या है. This is all we need to know. What is your basic law on reservation? Basic, और कुछ नहीं करना है. ठीक है. We understand that there is education based reservation. We understand there is employment based reservation. We understand that there are certain principles. There is SC, ST, OBC, and now you have EWS. This is your latest. We understand there is something called a carry forward rule. We understand there is something called reservation in recruitment and promotion, wherein you have consequential seniority. We understand that reservation cannot be more than 50%. This does not apply to EWS, very specifically mentioned in the constitution. There are few important judgments. Indira Sahni, we'll cover them in detail, don't worry. There is Indira Sahni, there is M. Nagaraj, and there is Jarnail Singh. These are the three important judgments. Recent में अभी क्या क्या हुआ है? Maratha issue, which has led to a recent constitutional amendment. There is the All India Quota medical case issue. There is the Haryana Sons of the Soil movement issue. Okay, ये हम cover करेंगे. Thank you, Shashi. We have to remember why are we here. We are here to clear the damn exam. Nothing else. Nothing else. Okay. All right. Done. For government schools, there is no reservation criteria. Devendra Singh Lanka. Arvind, that is why in the Jarnail Singh case, the Supreme Court said there is no need for you to analyze and give any data for it. The Jarnail Singh case partially overruled the Nagaraj case. Vishal, no, not at all. Vertical and horizontal is SC, ST, OBC, EWS is one layer, one dimension, and the second is, suppose there is women, so SC women, non-women SC. Govind, I've already answered that question. Yes. Contact at atishmathur.com. Ankit. Alright, the class is officially over. We are done with right to equality. Tomorrow we'll finish Article 19 and all related issues. कल बड़ा मजा आएगा. कल हम sedition, hate speech, press rights, Pegasus, वो सब Article 19 में हम merge करके पढ़ेंगे. ठीक है? Everything. Alright. Of course, Manthan, you will get that. Alright. Thank you.